To discuss why trustees are fiduciaries and the modern relevance of trust law, it is first necessary to understand what is the concept of a trust. James Penner defines a trust as equity's imposition of stringent personal obligations upon a legal owner to hold property for the benefit of another, with the result that he is no longer able to treat the property as his own. The legal owner of such property is called the trustee, whereas the people or persons for whose benefit the trustee holds and manages such property are called the beneficiaries. The first part of this answer will discuss why trustees are considered fiduciaries, focusing on their duty of loyalty to the beneficiaries. The second part will then examine the continued relevance of trust law in modern society, particularly within the commercial, private, and social contexts. In the case of Bristol and West Building Society and Matthew, a fiduciary was defined as someone who has undertaken to act for or on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. This definition can be divided into two components. Firstly, undertaking to act for or on behalf of another in a particular matter which, in trust law, is to manage the trust, and B, acting in circumstances which give rise to a relationship of trust and confidence. To explain the operation of A, trustees, on appointment, undertake to act on the trust affairs for the sole benefit of the beneficiaries. It therefore follows that a trustee is bound to relegate his personal interests in favor of his duties as trustee, for if he acted in his personal interests, there would arise a conflict between such interests and his duty to the trust, and this would be a breach of his duties. There is perhaps no clearer example of where such conflicts arise than when the trustee seeks to profit from his office of trusteeship. In Bray and Ford, a trustee unsuccessfully claimed for costs from the trust fund in bringing a liable action for comments made against himself as trustee. In dismissing the claim, the court stated that a fiduciary is not, unless otherwise expressly provided, entitled to make a profit. He is not allowed to put himself in a position where his interest and duty conflict. The court recognized a trustee as standing in fiduciary relation to the beneficiaries and declared the general rule that fiduciaries are not allowed to profit from their position. To explain the operation of B, the most obvious example of where a relationship of trust and confidence arises is when the trustee performs their duty to invest the trust property. This is compulsory, with Anthony Molloy, Queen's Counsel, noting that it is imperative that the trust estate be got into the trustee's name and invested. The beneficiaries have the right to expect that the trustee will attend to this, and the trustee has a duty to see to it. A beneficiary is merely the equitable owner of trust property as opposed to the legal owner, thus requiring legal intervention for the protection of their proprietary rights in the trust property. This underpins the beneficiary's negative right not to have the trust property invested improperly by the trustee, as opposed to a positive right to make investment decisions proactively. Hence, the beneficiary is heavily reliant on the trustee for the everyday management of the trust affairs, therefore placing their trust and confidence in the trustee to make prudent and appropriate investments. Next, this answer will examine the trustee's core duty of loyalty, identifying that it can be classified as a fiduciary duty. This is known as the trustee's duty to avoid conflicts of interest, or in other words, to act with undivided loyalty to the beneficiary. This duty underscores the whole of trust law, with Herbert Prochnow Jr. acknowledging that the duty of the trustee is to give undivided loyalty to his trust. The fiduciary principle is generally regarded as the most important principle in the law of trusts. This duty to avoid conflicts of interest can be subdivided into duties to, firstly, not make unauthorized profits, second, not purchase the trust property, third, not purchase the beneficiary's beneficial interest, and fourth, not compete with the trust. The rationale behind each of these duties is to achieve the ideal of a fiduciary relationship, that is, to effect a complete and total separation between the trustee's personal interest and his duties to the beneficiary. Concerning the first subdivided category, Haley and McMurtry state that a fiduciary is liable to his principal in respect of unauthorized gains obtained by reason of his fiduciary office. For example, in Boardman and Phipps, the fiduciary, a solicitor, purchased shares in a poorly run company, making himself and the trust the controlling shareholders. The company's fortunes improved and the investment increased in value. Despite the solicitor's actions being taken in good faith and resulting in a financial gain for the trust, the court upheld the principle that a fiduciary is not entitled to make a profit because they are disallowed from putting themselves in a position where their interest and duty conflict. Viscount Dilhorn stated they could not use that information to purchase the shares for themselves if there was any possibility that the trustees would wish to acquire them for the trust. The rationale behind his reasoning is that trustees should act with undivided loyalty to the beneficiary and place the interests of the trust above their own personal interests, especially when they possess information gained via their office of trusteeship. Sun Hang Tae agrees, stating that the reason behind holding fiduciaries to a strict standard is to protect the interests of the beneficiaries, therefore recognizing that the protection of beneficiaries' interests is paramount in trust law. Concerning the second subdivided category, Matthew Conaglan references the famous dictum of Megari, Viscount in Quito and Waddell, that states that a trustee is not allowed to purchase the trust property, in that, if a trustee sells the trust property to himself, the sale is voidable by an beneficiary ex debito justite, however fair the transaction. This is called the self-dealing rule. Hanbury and Martin add that this rule is based on the principle that a trustee may not place himself in a position where his duty and interest may conflict. For example, in Kane and Radley Kane, a widow was the sole administratrix of her husband's estate and appropriated shares worth £50,000 in satisfaction of the statutory legacy she was entitled to on the estate. This was without the consent of her stepsons, who were entitled to the legacy subject to her rights. She later sold the shares for over £1 million, and it was held that the appropriation of the shares breached the self dealing rule, equivalent to a trustee purchasing trust property. The widow was acting as trustee for the shares, as her stepsons were entitled to the shares subject to the widow's rights. By purchasing the shares, she purchased the trust property and caused a conflict between her interests and her duty to administer the estate. The preclusion of personal interests in favor of the trustee's duties is at the heart of the self-dealing rule, with Lord Eldon stating in Ex parte Lacy, a trustee shall not buy for himself, because the objective is to preclude the fiduciary from being swayed by considerations of personal interest, explained by Justice Dean in Chan and Zakaria. Concerning the third subdivided category, Malcolm Fitzsimmons states that the acquisition of a beneficiary's interest in the trust property by a trustee can be set aside unless the trustee proves that he took no advantage of his position, made full disclosure to the beneficiary, and that the transaction was fair and honest. This is known as the fair dealing rule. Through strict application of these conditions, the courts safeguard the fiduciary relationship between a trustee and their beneficiary, ensuring that the trustee does not purchase the beneficiary's beneficial interest by coercion, duress, or other deceptive methods. It gives material effect to the spirit of the fiduciary relationship, the loyalty of a fiduciary to its principal. In Crowles and Dracothick, a beneficiary was content with the sale of the trust property. The sale was upheld, with Lord Eldon explaining that a trustee may buy from a beneficiary provided that there is a distinct and clear contract, proving that the beneficiary intended that the trustee should buy, and there is no fraud, no concealment, no advantage taken by the trustee of information acquired by him in the character of trustee. This evidences a fiduciary relationship because the trustee is held to a high standard of loyalty and transparency. The trustee must not misuse information learned from his office to gain an advantage over the beneficiary, proving that the beneficiary trustee relationship is based on trust and confidence. Concerning the fourth and final subdivided category, Haley and McMurtry state that the general rule is that a trustee may not enter into business competition with the trust. In Reed Thompson, Justice Clausen stated, the rule of universal application is that a trustee having duties to discharge of a fiduciary nature towards the beneficiaries, in this particular case, the duty of a fiduciary nature was to carry on the business of the testator to the best advantage of the beneficiaries, he shall not be allowed to enter into any engagement in which he has or can have a personal interest conflicting with the interests of those who he is bound to protect. The personal business of the trustee was reined in because it created a conflict of interest with his duties as trustee. The trustee had carried on a yacht broker business in the same town where the trust's yacht broker business operated, and the nature of the businesses were so highly specialized that there arose an inevitability of conflict. There were only so many buying customers either business could broker yachts to before they entered direct competition for customers. The Columbia Law Journal puts the principle of this case simply, in that a trustee operating a business for a decedent may not compete with the beneficiary's enterprise. The principle that such competition be excluded is clearly in line with the fiduciary spirit of loyalty and honesty. This answer will now discuss the relevance of trust law in modern society, focusing on three main areas. the commercial, private, and social contexts. Firstly, trust principles underpin much of modern commerce. In pension funds and unit trusts, trustees manage large sums of assets for numerous investors, their beneficiaries, with Theo Tang Tang noting that unit trusts are one of the essential investment vehicles in the Malaysian economy. The same fiduciary standards that apply in traditional trusts ensure that commercial trustees act with honesty and impartiality when handling large sums of money. This fairness and efficiency in management has led to a threefold increase in the number of registered unit trust management companies from 1992 to 2009 in Malaysia. The adaptability of trust law principles to such commercial contexts demonstrate their continuing relevance as mechanisms for safeguarding investments and distributing benefits to investors. Secondly, trust law remains widely used in private matters such as estate planning and the protection of dependents. Despite 8.75 billion ringgit in unclaimed assets remaining frozen in 2020 due to the absence of estate planning on the settler's part, it is argued that estate planning and trust law become increasingly relevant because such large sums of money are frozen under legal procedure. Through instruments such as discretionary trusts, property can be managed for the benefit of minors, the elderly, or those who are incapable of handling their own affairs. This ensures that the settlers' assets are preserved and used responsibly. Additionally, in family contexts, the trustee's fiduciary duties ensure that personal relationships are balanced by equity's emphasis on loyalty and accountability, making trusts indispensable tools for managing wealth and protecting vulnerable individuals or family members. Lastly, trust law also remains relevant through its application to charitable trusts, which support social welfare. These trusts are more exceptional than private trusts, with Jonathan Fowles recounting Lord Macnaghten's dictum in Pemsl's case, stating that the Court of Chancery has always regarded with peculiar favour those trusts of a public nature which, according to the doctrine of the court derived from the piety of early times, are considered to be charitable. They allow for the management of property for purposes that advance education, relieve poverty, or promote health or some other public benefit. These trusts enable resources to serve public ends while ensuring trustees are accountable via fiduciary oversight. Besides the causes above stated, public trusts are increasingly used in fields such as environmental and cultural preservation, where assets are managed for the collective benefit of society. This reliance on trust law principles in managing property for society wide benefit reflects its enduring relevance in modern society. To conclude, it can be said that a trustee is a fiduciary because they act with undivided loyalty to the beneficiary, or in other words, they act in the beneficiary's interest to the exclusion of their own or a third party's interest. Indeed, trust law continues to be relevant in modern society, especially in the context of pension schemes, unit trusts, estate planning, and charitable trusts. And this relevance shall endure due to the adaptability of trust law principles to societal needs.